I no, that's like one of
Hello, everybody. Good evening, good afternoon, depending on where you're streaming from. This is Carla Frade. I'm from the Center for Art Law. I'm the Judith Breslin Fellow, and it is my pleasure to welcome you all to our Art and Copyright Law Clinic. And just before I hand it over to our today's speaker, I would like to take a moment to give you a brief introduction on the center and a bit about the work that we do. So the Center for Art Law is a Brooklyn-based research and education nonprofit. We are dedicated to offering resources and programming to advance the arts and law communities. Through our website, newsletter, and events, we disseminate information and update our audiences on all things art law. So whether that be news, programs, cases, publications, and a lot more. We also facilitate conversations and learning opportunities such as this one, and also webinars, workshops, and other events. We invite you to subscribe to our newsletter so you can learn more about what our offerings are and catch up on everything art law related. You may also consider becoming a premium member. Memberships are discounted for artists and students. It also allows you to access our case law database, past event recordings, and discounted tickets to our events, and many other benefits. A bit on our upcoming events. We are hosting quite a few offerings until the end of the year. Next week, for attorneys in the audience, we are having a CLE webinar on ethics for attorneys, appraisal, and other art professionals. That's 1.0 credits. On the following week, we will be having the final of our third-part workshop on fiduciary duties, focusing on trustees of estates. And in December, we will have a very interesting copyright registration workshop, which I think you will find very useful. And finally, an artist-dealer clinic on artist-dealer relationships. I invite you to attend as many as you can. To learn about our programs, you can subscribe to our newsletter, also find us on social media. And if you really are considering getting more involved,
tomorrow
you can write to us
morning.
and
You're saying
become a premium member of the center. Before I hand it over, just a few housekeeping items. This lecture is being recorded. Our consultations are private and confidential. Those will not be recorded. Feel free to turn on your camera, but please keep your microphones muted. Handout will be shared with you in the chat. It contains a few resources for those who are looking to dive deeper into the subject. And if you have any questions on the presentation, feel free to post them in the chat box. We will address them at the end of the session. So moving to, without further ado, let me introduce you to Lindsay Korotkin, our guest speaker for the night. She's a partner at ArentFoxSchiff Intellectual Property Department. She is also a member of the Center's Advisory Board. We are very happy to have her here with us. Thank you so much for accepting our invitation, Lindsay. Due to time constraints, I will not be able to read her full bio, but you can read all about the wonderful work that she does in the handout that we'll share with you on the chat. So that's it for me. I'll hand it over to you, Lindsay, and stop my screen sharing so you can share yours. Thank you so much.
Great. Thank you, Carla. Okay. I'm here. Can everyone see my screen?
Not yet.
Okay. Let me come back to here. I'm usually very tech savvy, but I'm taking this event from New Orleans and I'm on my laptop. So bear with me for 1 second. There we go. Okay, everyone should hear me now, see me now. Yes? Great. Okay, hi everyone. Thank you for joining. I'm so happy to be here. I'm a partner at ArentFoxSchiff. I work with brands and creators, helping them protect, register, buy, license, and sell copyrights, trademarks, and other creative work product. My colleague, Elizabeth Denning, is also on the call, and I wanted to thank her because she was also instrumental in helping us get ready for this talk. So starting off just with the agenda, we're going to start with some level setting quickly go over the basics of copyright law and protection in the US. We'll then get into common types of copyright contracts. We'll move on to considerations for artists when entering into copyright contracts. And you can't do a presentation this day and age without touching on AI. So we will end with some brief discussion of the intersection of AI, copyrights, and contracts. So starting off at the beginning, what are copyrights? Copyrights in the US it's a legal protection in original works of authorship fixed in any tangible medium of expression. It's important to remember that copyrights in the United States exist as soon as the work is created, as soon as the work is fixed. But it's great that the center has a presentation coming up on registration, because registration is very important. If you're in a situation where someone is infringing your copyrights in the United States, you are going to need a registration in order to file a lawsuit. That's important. Under the old laws, in application in some courts used to be enough, but now you really need an actual registration in hand in order to sue. Copyright law does not protect ideas. It only protects expression. This is something that comes up a lot with art, and that is really important. Someone else could make a painting that comprises the same idea, but if the expression is different and original to that second creator, it likely won't be deemed infringing. Copyright law covers a lot of different things in the world of art. The protection that we're usually talking about is protection for paintings, sculptures, or audiovisual works. It's important to remember that there are limitations on what copyright law does protect. So in addition to the rule that ideas are not protectable, the Copyright Office and courts are also clear that there's no protection for things like basic shapes or short phrases. Another issue that comes up a lot, which we'll talk about again at the AI section, is that copyright law does not protect works that lack human authorship. There was a funny case that people may have seen in the news several years ago. There was a photograph taken by a monkey. It was basically a selfie by a monkey. And there was a question about whether or not that photograph was copyrightable. It was adjudicated and determined, that photograph could not claim copyright protection because a monkey took the picture, not a person. There was no human authorship, and therefore there could be no copyright protection. Ownership is a very, very important topic in the world of copyright, and it's really front and center and something artists and creators should focus on. Usually the author, the person who created the work, is the author. There are some important exceptions. One of the big ones is the work made for hire doctrine, which is something I think a lot of people on the call have heard about. When something is considered a work made for hire, the employer or the person who engaged the creator and hired them is deemed the owner. This usually comes up in a corporate context. There are really two ways that a work can be deemed a work made for hire. The first is a work is made by an employee done within the scope of their employment. The other way is that parties can sign an agreement, some sort of contract that says, we agree this work is a work for hire, even though I'm an independent contractor, I'm not an employee, or I'm doing this outside of the scope of my employment. People get a little bit tripped up about this because this is a provision that is in the Copyright Act, and there are only a few categories of works where parties can contract to agree that something is a work made for hire. Most art falls outside of that scope, but motion pictures and other audiovisual works do fall within that category. And a lot of this has to do with lobbying from those industries to get that provision to ensure that studios or the people making the films end up with the relevant ownership rights. That all being said, those are kind of the baseline rules around works made for hire. Parties can always contract around these rules. In practically speaking, unless an artist has a tremendous amount of leverage or market power, it can be difficult to try to retain copyright if you're, for example, doing work as an employee within the scope of your employment. But it's something to keep in mind that you can try to ask for exceptions to these rules, but you have to make sure your contracts address them. Another important thing is joint works. If there are multiple authors, they're each going to own interest in the copyright. So you want to make sure if you're creating works with partners that you have an understanding up front about ownership, whether you're going to jointly own, and if not, we'll get into some of the different contracts that you can try to get executed and implement in order to protect your ownership rights and avoid a situation with joint ownership, which can be a wonderful thing, but can also lead to litigation and confusion and some complications down the road. The other exception is works in the public domain. Copyright terms are limited and the timing depends on when the work was created, but generally for our purposes, if a work was made in 1978 or after, the term is going to be the life of the author plus 70 years. Outside of that, no one owns the work. It's in the public domain. Anyone can use it in any way that they'd like. Why does copyright matter? Copyright is really considered a bundle of rights that is granted to the owner of the copyright. Anyone who uses those rights or exploits those rights in some way without permission could be found liable for copyright infringement. There are really 5 key areas of protection when it comes to what copyright law is actually protecting in the United States. One is the right to reproduce the work. The second is the right to make adaptations or what we call derivatives. The third is the right to publish the work. Fourth is the right to perform the work when the work is capable of being performed. And the last one is the right to display the work. In order to prove infringement, you have to generally prove copying and substantial similarity. There are a lot of different defenses. Each case dealing with the claim of copyright infringement really depends on the facts, but common defenses that we see are claims of no infringement, either because a party did not copy the work at all or did not copy the protectable elements. Remember, ideas are not protectable, so copying an idea and not the expression is probably going to be a pretty good defense to a copyright claim. The other related defense we often see is just the works aren't similar. Yes, I admit that there was some copying, but the outcome is sufficiently different, and what I did is not infringing. Sometimes people also argue that the works aren't protectable. For example, the plaintiff isn't the owner or the works are in the public domain. And then last but not least, something I think everyone on this call has heard about is the question of fair use. Fair use is a defense to copyright infringement. It is a fascinating topic. We could have a whole talk just on fair use. It's important to remember that this is a case-by-case doctrine. Courts or a jury have to really consider each factor and apply it to the facts of this case. For this reason, a lawyer could never give an opinion saying this use is absolutely fair use. The best case you could get is, I think you have good arguments for fair use. I recommend, you go forward with that strategy, or, I don't believe you have a good case for fair use, and I recommend making some changes. There are 4 general factors. What is the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effects upon the potential market or value of the copyrighted work. With all that background, we can move into what are the common types of copyright contracts that we see. There are really 2 types when it comes to dealing with issues around ownerships or right to use or not use the work. They are licenses and assignments. They both control and govern some transfer of interests in the copyrighted work. Licenses are basically akin to a rental agreement. Under a license agreement, the creator or the owner retains ownership of the copyright and is granting specific rights to a third party to use the work or elements of the work for a set period of time. There's usually some sort of payment, either a lump sum or some sort of royalty on a quarterly or annual basis. But that all being said, the copyright owner, the creator, retains ownership and has to take steps to protect the work and make sure that others are infringing and all the things that come with owning a protectable interest in a copyright. The other type of contract we see is an assignment. It's a very different animal. In assignment, is where an owner or creator transfers all of their copyright interest, all of their rights to another party. It's possible that parties can sometimes assign in piecemeal, but for purposes of this discussion, we're just talking about copyrights as a transfer of full ownership. This is a permanent transfer. Once you assign your rights to someone else, you can't get them back. If you don't like them, you don't like what they're doing with the work, it does not matter. Copyright assignments, it's a permanent transfer. The person you transfer to is the owner. That's it. Payment, again, all these agreements can be structured in different ways. It's typical that when you're assigning a work, you have a lump sum payment, but there can always be business reasons for people to depart from that. Let's quickly go over some common terms in copyright contracts that you guys should be aware of. For licenses, some of the key provisions will be the grant of rights, where the parties are focused on what specific rights are being licensed. And a key thing I'll flag that's important for artists to think about is whether or not you're granting someone a license to make derivatives or adaptions of your work. So an example of a derivative, for example, might be to turn a regular book into an audiobook or to turn a painting into an NFT. There's a lot of litigation out there when licenses do not state expressly whether or not derivative rights are being licensed or not. So I always advise anyone when I'm working on a license to just make sure that that's clear in there and upfront, because it creates a lot of headaches, a lot of trouble, can lead to a lot of litigation if there's any ambiguity there. Another very important question and provision under the grant of rights term is whether or not the rights are sub-licensable. If you don't want the licensee to be able to work with someone else or basically substitute someone else in for some of the work that they're doing, you need to be very clear about that, or maybe set in conditions like a sub-license is permitted but requires some sort of vetting or pre-approval. The scope of the license grant is also very important. You want to make sure that the license is clear about whether the grant is global or regional, whether the grant is exclusive or not exclusive. Can you have other licensees, or are you really just having one licensee, it's exclusive, and no one else can exploit the work during the time period of the agreement? Again, duration, very important. Is this a limited license or will it go on forever? Lastly, is the license renewable? This is also very important. If the license is renewable, it's important. If there are any conditions you want to put in place, for example, the license could be renewed on an annual basis if certain sales quotas are met. We're always looking for those kinds of provisions to make sure that the licensor is protected if the relationship isn't working out. License agreements also must address what is the compensation. Is there going to be a one-time fee or royalty? If there is a royalty, very important to make sure it's clear about what it's based on. Is it based on revenue or profits? Are there any deductions that parties can implement before calculating what the royalty is? I'm sure everyone's heard things like Hollywood accounting. There's a lot of games that parties can play with the numbers in order to figure out, what gets deducted before calculating a royalty. So very important that license agreements are clear about how to make that calculation so that there's no risk of litigation and no risk of someone potentially not getting paid what they think they should. Related to that, a good license agreement usually addresses audit rights in books and records. You want to make sure that someone you're licensing with has an obligation to keep recordings of all of their sales activities, all of their costs, all of their profits. So if there is a fight down the road, which happens often, especially in the music industry, you can get through discovery or through just a contractual requirement to open up books and records to really inspect those documents and those sales records to see if there was, any funny business or games going on with the numbers that went in to determine a royalty rate. Lastly, revocability and early termination. It's very common in a license agreement for there to be terms around how the agreement can be revoked or ended early. And so depending on whether you're a licensor or a licensee, you want to make sure that those terms comport with really your interests in how you want the relationship to go and exit paths if you need to get out. Assignments typically are shorter. The key terms there are the description of the work. You want to make sure the assignment is crystal clear about what you are assigning. And if there's something you're not assigning, making sure there's no ambiguity there, making sure the payment term is clear, and then very important that the assigner, the person who's giving away their rights, signs the assignment. That's a requirement for it to be legally effective. Common terms that come up for both licenses and assignments, making sure the agreement addresses whether or not it covers new technologies that could be developed after the fact. This was a big thing when ebooks and audiobooks came out. There was a lot of litigation around whether different kinds of agreements covered exploitation through derivatives of an ebook or an audiobook. So that's something to keep in mind because we can't always foresee what technology will come out in the future. So putting in some magic language can sometimes protect parties if the goal is to be able to exploit in any way possible. Representations and warranties are also very important terms. Typically, the person receiving the rights wants the person giving away the rights, the licensor or the assignor, to represent that they own the work and that use of the work won't infringe someone else's rights. If that turns out to not be true, you want to be able to sue for a breach of those representations and warranties. Confidentiality sometimes can be something that parties want as well. So that's a provision to think about. And if there is a confidentiality provision, you want to make sure you have exceptions so you can share the agreement with your accountants, your lawyers, your investors, or otherwise. Dispute resolution is also very important. There's often a preference to avoid public lawsuits. And so there are some options that parties can look into, including mandatory mediation or arbitration. It's also a good idea if you want to have a good working relationship with the party that you're contracting with to put in notice and cure provisions. Under those provisions, if someone thinks that someone violated the contract in some way or there was a breach, there's an obligation to basically communicate, work together, give the other side a period to fix the problem before you go after them and sue them. Very, very helpful. A lot of times issues can be resolved pretty quickly and out of the public eye, which can always, create embarrassment and potentially even tarnish brands or artist reputations. Common concerns for artists in these kinds of contracts. We've touched on it a little bit already, but with licenses, one of the main issues is just making sure as an artist, as a creator, you're maintaining the control over your work that you want, making sure you understand exactly what rights you're giving away and what you're not, making sure that you have termination provisions in place. If the partnership is not working out, you want to have good exit opportunities. This was something I saw come up a lot, especially in the fashion space during COVID, where there were a lot of license relationships that were not working because no one expected that, supply chains would shut down, the whole world would shut down. And so, we worked with a lot of brands and people in the licensing world who had good termination provisions and a lot who didn't. And the ones who didn't, it was really tricky to navigate how to get out of those agreements or how to modify them in some way so that, the businesses really could go forward in some sort of an economically productive way. Remember, very, very important, licenses can be verbal or written. So if someone calls you, and says, can I use your image on this book cover? And you say yes, that could be a legally enforceable license, even without signing anything. In contrast, assignments, very different. Assignments make sense for policy reasons, have to be signed by the person giving away their rights. So if someone calls you and says, can I own the photograph that you took and you give me all rights to it, and then I'm going to use it on a book cover and I may use it for other things. And you say yes, but you haven't signed anything. The best thing they could say is that you gave them a perpetual license and it was verbal, but they're not going to win if they say that was an assignment of rights if there was no signature. Just a quick cautionary tale as we start to move over to the AI question. Keep in mind that social media platforms have terms of service. These terms of service typically have copyright licensing language. I'm sure some people are familiar with the idea of, remixing or reposting. Make sure that you know what platform you're using, what their terms are, what you are and are not granting, because you don't want to be in a situation where you post something, it shows up somewhere else on the platform, or otherwise you think it's an infringement, and then it turns out that actually you agreed to something through those terms of service that you didn't anticipate. And I'll flag for you guys, there's a little bit of a controversy, especially California courts in the Ninth Circuit versus New York courts, about whether or not displaying content that's linked to someone else's post, it's just embedded content, you haven't created an actual copy, whether or not that is copyright infringement. The Ninth Circuit, under a test they call the server test, typically holds that that's not infringement. They say the question is really, where is the server, who owns the server that's posting the content, and if it's still the original creator, then you haven't done anything wrong. It's just the link, and links aren't copyright infringement, and courts in New York tend to disagree. So that takes us over to AI and the implications that it has for copyright and copyright licensing. We are in the Wild West. This is still a gray area. Things are changing rapidly. New cases are being filed almost every day. High level, courts and the Copyright Office have not yet definitively ruled on whether or not using copyrighted works to train AI models is copyright infringement. Within the next year or two, I think we'll have some decisions from some of these courts. We'll have a little bit more guidance, and we can reassess where the landscape is there now. But for now, the things that we do know is, one, per the U.S. Copyright Office, if you have a work that's created using AI, that work is generally not copyrightable. This ties back to the rule we talked about at the beginning. In order to be copyrightable, works have to be created by a human. So if a monkey takes a picture and the monkey can't have a copyright, then neither can someone who just puts in prompts and the AI actually does the work to create the outcome. That being said, of course, this is the world of copyright. There's always gray areas, and there's even gray areas here. What we do know, and what we've seen from the Copyright Office's application of this rule to date, is that when a work is solely generated by AI, the Copyright Office will deny registration and determine that the work is not protectable. Remember, not protectable also means that if someone copies your work, you cannot sue them for copyright infringement. The work is considered not copyrightable, and you also don't have a registration, which you need in the US in order to sue. So it's very important, especially for AI artists, to understand the implications of using AI as the sole technology to create the work. The good news, though, is that when works are partially created or altered with AI, the Copyright Office will usually take the position that the work is registrable, but the AI created or altered content has to be identified and disclaimed in the application. The bad news is that also means that you can't own that portion of the work effectively. So, the general guidance we do have for artists is it's okay, if you're going to use AI in some capacity, you want to try to make sure that you document exactly how you're using the AI, because whether it's to get a registration or in a litigation, you might need to actually be able to disclose that and defend it, so that you can demonstrate that there was a lot of human involvement and your work actually is protectable, at least in some capacity. And then just closing things out, there's a lot of licensing considerations when it comes to the world of AI. Artists can consider licensing their works to AI companies, and some artists have been doing this. It's a practice, at least for now, until we have court decisions about whether or not using copyrighted works and training AI models is infringing or not. The pros, obviously, getting some level of compensation and certainty. If the AI companies are doing this anyway, at least you've tried to use some negotiation power to try to set the terms around what they can and cannot do. Cons, I think, are pretty self-evident. You're potentially enabling someone else to copy your work or your style, potential loss of control for your work or your style. results in self-dilution. Potentially, you may get some compensation, but are you, in the end, hurting your overall market power because it's much more easy to copy your style in some capacity? There are some trends we've seen, though. There have been some rights owners and publishers, as I mentioned, that have been licensing some or all of their catalogs to AI developers. One interesting example is Getty Images licensed photographs to NVIDIA, and the agreement that they reached is that there would be royalty payments paid back to the artist in some capacity. You should also keep your eyes open. The Artist Rights Society takes a lot of great open public positions on these AI issues and has recently expressed some concern to the Copyright Office about a lot of these issues, and has taken the position that a voluntary collective licensing solution for artists might be a good and fair solution to the question of whether or not these AI platforms can use artists' work in training their models, and how it impacts potential outcomes for those, for works created through those platforms. So I know we sort of covered a lot of things. Hopefully this helps provide some guidance or clears up some issues. I think we do have a few minutes for questions before you guys break out into the one-on-one confidential consultations. So if anyone has a question, you can put it in the chat or raise your hand, and I'll do my best to answer it.
Thank you so much, Lindsay. It was a lot to cover, and it was very informative. I don't see any questions in the chat for now, but I do have one question on my side. I understand that copyright contracts need to be recorded with the U.S. Copyright Office. I was wondering if you maybe could explain what that means. Is it mandatory? Is it optional, just like registration?
So if you have an assignment, you're definitely going to want to record the assignment so that there's public notice, and that everyone knows exactly who is the owner of the work. And there's a public database that you can look up to see who owns what. You don't have an obligation to record license agreements, but it's important to note if you're having a license that has global reach or a reach outside of the US, you should consult with a lawyer, because different countries do have different requirements. And the trend is away from recording license agreements, but there are still some jurisdictions that have some requirements. So you want to make sure that you're checking with a lawyer, checking with some sort of copyright office or regulatory body to make sure you're doing what you need to.
Perfect, thank you. And please, all participants, if you have any questions, just feel free to drop them on the chat. I'll be moderating them.
Don't be shy.
May I ask you a question?
Yes.
Yes.
Well, I'm an attorney too, but I was just curious because I know artists have been interested in licensing, but have you been involved in the negotiation of a licensing to use the works for training?
Some of my colleagues have. I personally have not.
Okay. Yeah. Thank you.
Yeah. And if anyone just has a comment, it doesn't have to be a question. I know it's an evolving area of law, and AI is also an interesting topic. People have opinions on it. So always curious to hear what boots on the ground, what you guys are thinking or feeling about what's going on.
We have a question from Jay on the chat. He's asking if a work is made as a work for hire, does life of the author refer to the author or the employer?
Yeah, it's different for if it's corporation. I believe right now it would be a 95-year term. We didn't get into it, but before the rules before 1978 are a little bit different, and there was actually a prior Copyright Act, and there's the cases are starting to sunset out, but there's historically been a lot of litigation just around even, whether or not someone renewed their copyright, whether or not it was registered properly. Also some fascinating litigation around what was even protected, looking at something you guys will learn about on the next registration panel is, you have to put in a deposit with the Copyright Office, and that really demonstrates what you are protecting, what are the metes and bounds of what you are protecting when you file a copyright application. And there have been some cases where, parties went back through the records and pulled up the deposit, and it turned out that the registration protected something very different or more limited than what the parties really thought the registration protected.
Very interesting. Thank you.
Yeah.
So yes, one last question, and then we'll be done because we have to send people for their consultations. Liam is asking if there have been any major disputes related to international trade and countries having differing copyright laws.
Yeah, that's a great question. So there are some international treaties. The US is a member to the Berne Convention, and it's a little bit complicated, but basically, as a member of this convention, any participant is supposed to, you can't prejudice the rights of someone else who has a registration in another country. So you can technically sue for copyright infringement through the Berne Convention in a US court. And I've had some cases dealing with this issue, but the way at least the US courts tend to treat the issue is there still needs to be some meaningful effect in the United States, some relationship. US courts don't want to be arbiters of completely foreign disputes over foreign copyright laws. But that's definitely is one area that's interesting and gets litigated a lot. People tend to want to litigate in the United States if they can, just because we have very robust discovery tools. In some foreign countries, you can't get as many documents. That being said, litigation in the United States is much more expensive. So when you're dealing with issues where there are claims for copyright protection in different countries, or the parties are in different countries, you want to make sure that you're consulting with a lawyer, really thinking about the pros and cons of how you go about pursuing the case and where you pursue the case, because there's different procedural rules, sometimes rights and remedies to consider. But it's international copyright law is a fascinating topic, and something that does come up a lot.
Perfect. Thank you so much, Lindsay. Thank you, the attendees, for the questions. I'm afraid we have run out of time for this part of the for the clinic. But thank you all for attending. If you have a Keynote ticket, that will be all for you, and you feel free to disconnect.